All right, we'll get underway. Welcome, everybody. I'm Luke Hook, the General Manager of Policy at the VFF. And today we've got our EPA Act seminar for the Livestock Group presented by Ashurt lawyers. So letting you all know that today's presentation is going to be recorded. That's so that we can clip it up and send it to yourselves and all of our livestock members, and also have it as an online resource. So you can view it whenever you like. We'll also be sending out a fact sheet which summarises the information that you'll be receiving today, and we'll include any questions that arise throughout the, any answers to questions that arise throughout the seminar today when we send that out as well. So I'll hand it over to Jane Hall and Sophie Westland from Ashurt.
Thanks very much, Luke, and good morning, everybody. Unfortunately, we're all in separate parts of, I presume, Victoria, and so I would like to respectfully acknowledge the traditional custodians of the land from which I'm presenting and from which Sophie's presenting, and from the lands upon which you're dialing in from. And I pay my respects to their elders past, present and emerging. Now, as I said, in an ideal world, we'd be sitting around a table and having a bit of a chat and really getting some interaction going in relation to this presentation. And so just because we're in a virtual world, we do still encourage you to put your hand up, take yourself off mute, yell out if you've got any questions as we go along. Sometimes, you know, if we get really carried away with a discussion, we might have to cut it short just so we get through the materials. But we really do encourage you to make the most of this session that's been organised so that you understand the new laws that have been introduced. So in terms of what we're aiming to cover today, we are obviously going to tell you what the relevant act that you need to know about is and why we're talking about it. We're going to talk to you about the cornerstone of that new law, which is known as the General Environmental Duty. We'll look at some of the permissions you might require under the Act, and then take a bit of a whistle-stop tour in relation to some of the big topics that's covered by the new laws, being waste, noise, odour, contaminated land and pollution incidents. And then we'll look at some of the EPA's powers, some of the review rights that are built into the Act, and then most importantly, have time at the end for some case studies where we hopefully bring all of that content together so that we can sort of run through how it all might fit together in a context that's relevant for you guys. So turning to the new EPA Act, the Act that you need to know about is called the Environment Protection Act 2017. It's pretty exciting for environmental lawyers on the basis that this is the first time we've really had a complete overhaul of the Act since 1970. And it was meant to commence in July of last year, so 1 July 2020. But due to COVID, it was actually pushed back and only commenced 1 July of this year. So it's still relatively new. A lot of the sort of information we're giving you is our sort of best understanding of how the EPA is actually going to implement this on the ground. But obviously that understanding will develop as we actually see the EPA in practice over the coming months and years. One of the main features of the regime is that it brings to the EPA for the first time a single statutory objective of protecting human health and the environment by reducing harmful effects of pollution and waste. And really, that puts human health at the front and centre of everything that the EPA does for the first time ever. And you can probably appreciate that some of those big ticket environmental incidents that have occurred in recent times, be they the Latrobe Valley fires or some of the recycling fires, for example, the one at Coolaroo, the sort of smoke plumes that arise from those incidents create not only an environmental issue, but also very much a health issue for those local communities that are affected. So it's probably no surprise that the new regime puts health in fairly and squarely within the EPA's remit as well as the environment. The other thing to note is that human health includes psychological health, in recognition that, you know, often environmental incidents do affect people's mental well-being as well as physical health. And we're sort of thinking particularly odour and noise as falling into those categories. So it's not yet clear how that's going to be assessed, regulated or managed, but just to sort of note that when we're talking about health during the rest of the presentation, we're not just talking about physical health. Excuse me. Now on the slide, you can see there quite a detailed slide. It's been put in, we're not going to run through it now, but hopefully it's a bit of a cheat sheet that you can refer back to later on, as well as the handouts that Luke will be distributing, to give you sort of a bit of a summary of what the situation was under the 1970 Act and what the situation is now. So just remember that slide is in the pack of materials for you to refer back to at a later stage if you need to. So if we turn to the cornerstone of the new regime, it's called the General Environmental Duty. And for those of you who might be familiar with how the 1970 Act operated, you might be aware that really the EPA got involved when there had been an environmental incident. So there were pollution offences, there was pollution of atmosphere, land and waters. And at the time when something had occurred to pollute one of those environmental mediums, that's when the EPA got involved and either issued enforcement sort of regulatory notices or prosecuted for an offence against those offence provisions. That was obviously a very reactive way of dealing with environmental regulation, and that has been completely overturned in this new regulatory regime, in that the focus of the new Act is to prevent harm from occurring in the first place. So people carrying out activities, and we'll deal in a bit more detail in a minute as to who are these duty holders, but generally a person that's carrying out an activity has a positive obligation to implement reasonably practicable steps to minimise risks of harm from pollution and waste to human health and the environment. It's important to understand that that obligation firstly requires you to try and eliminate the risks of harm to human health and the environment. And if it's not reasonably practicable to eliminate, then you are required to reduce those risks so far as reasonably practicable. So summing that concept up, it's not necessary for the EPA to wait for there to be an environmental issue or an environmental pollution event for them to prosecute somebody for breaching this general environmental duty. And I have deliberately said prosecute there because it is a criminal offence to fail to comply with this general environmental duty. So what you need to be able to do is show the EPA that you've considered this general environmental duty and done everything reasonably practicable to eliminate or minimise risks of harm. So that obviously includes, well, understanding what are these risks that arise from the particular activities that you're undertaking, considering whether there are mitigation strategies that you can implement to address those risks. That might be signage, training, redesigning something, or updating your procedures or practices. And then assessing, well, which of those control methods are reasonably practicable to implement, and obviously implementing them. And then regularly reviewing changes and strategies and incidents that could occur so that you're forever, I guess, reviewing and updating and improving those risk mitigation strategies and your understanding of the risks as you go along. So you really will need to sort of sit down and look at all of the different activities that you're undertaking across the portfolio of your operations. And it won't be enough to just have sort of a generic off-the-shelf risk assessment and sort of blanketly say that that is your assessment and then put it on the shelf and forget about it again. So turning to the next slide, you can see here that the general environmental duty, as I said, applies to people who are engaging in an activity that can give risks, rise to the risks of harm. And that concept of somebody engaging in an activity is defined quite broadly in the Act, and it includes a person who's conducting, undertaking, managing, or in control of that activity. So just because you've contracted to a contractor to undertake part of an activity for you or on your behalf, that doesn't necessarily mean that you will have passed on that responsibility to comply with the general environmental duty in relation to that activity. And you might be wanting me to give you sort of an easy answer as to knowing when you have sort of passed on that responsibility and when you haven't to a contractor. But unfortunately, it's not that sort of clear cut, and it will depend on, you know, the contractual arrangements in place, what you've been asking that contractor to do, what their expertise is compared to your expertise, and various other factors that we could spend a lot of time on alone talking about. So just bear in mind that the fact that you've engaged somebody else to help you doesn't mean that you won't have the duty as well. And the other thing to note is that activity itself is defined very broadly. You can see in that middle box that includes the storage or possession of waste, for example. The other thing to note is that if you engage somebody to design or manufacture, for example, a product or a system, then that, what we call upstream duty holder, also has a general environmental duty to design that product or piece of kit in a way that minimises pollution or waste when that thing is being used in the way it was intended, as well as providing you with the necessary information to ensure that you can use it in the way it was intended. So you might now be thinking, if we go to the next slide, well, one of the key concepts that I need to understand is, well, how do I know if I'm doing what's reasonably practicable in a particular situation? And the Act itself talks about a few things that if you're not doing it, you will not be complying with your duty. So the things that you have to be doing are using and maintaining plant, equipment and processes in a manner that minimises risks of harm, using and maintaining those systems to identify, assess and control those risks of harm, and to evaluate the effectiveness of controls that you can implement, as well as using and maintaining systems to ensure that if the risk of harm actually does arise, that you've got a way of minimising the harmful effects that result. You need to be ensuring that all substances are handled, stored, used or transported in a manner that minimises risks. And this is an interesting one, this last one. You need a statutory, effectively, obligation to provide information, instruction, supervision and training to people engaged in the activity to enable those people to comply with the general environmental duty. So you really do have a positive obligation to take this back to the people that are working as part of your enterprise, to educate them as to this general environmental duty and the systems and processes that you have identified and need implemented in order to manage and minimise those risks of harm. On the slide, you can see a number of factors that the EPA and therefore the courts will consider when determining whether something is reasonably practicable or not. And you can see there that the first two boxes, the likelihood of the risks and the degree of harm that would result, is a pretty standard risk assessment methodology. So that shouldn't be too much of a surprise. But also included in that assessment is the knowledge that you have or should have had about the risks of harm to human health and the environment, the ways that are actually available of eliminating or reducing those risks, but also the availability, suitability and cost of eliminating or reducing the risks. And the information that's been published and the guidance that's been issued by the EPA really talks about a proportionate response being required. So if you've got a big risk that could result in material harm, the EPA is going to be expecting you to do more, as opposed to if you've got a risk that's unlikely to arise and really the consequences are not that great if it does arise, then you'll be expected to do less to manage that risk. So it really is all about proportionality. But I think one of the biggest things that we're telling people is that you really need to have this sort of risk assessment available in a documented form that you can then provide to people such as the EPA to give them comfort that you understand the duty and you know what your risks are that arise, and you've assessed what the options are to minimise them, and that you've done some sort of thorough but acceptable, reasonable analysis as to what it is that you're going to do to minimise those risks. So I might just pause there. Does anyone have any questions about the general environmental duty? No, I've either completely confused you or that's all as clear as mud. So hopefully it's the former. So we'll keep pressing on. The next slide we've just included to give you an indication that this is a big change for how environmental law is regulated, or how the environment is regulated in Victoria. The EPA recognises that, or the government recognises that. And so they have included in the Act a transitional offence that will apply, we understand, for a period of around 2 years from the Act commencing on 1 July of this year, which gives the EPA the ability to prosecute somebody in the event that there has actually been material harm to the environment. So instead of being prosecuted for failing to implement systems to manage risk, which is what the general environmental duty is all about, the EPA for this transitional period could actually pursue people for harm to the environment. And you can see on the slide there, material harm is all about costs in excess of $10,000 being incurred to effectively prevent or minimise the harm or fix it up after it's occurred. So just be mindful that that's in there. We're not really quite sure yet how the EPA will pursue that, or whether it will pursue a breach of the general environmental duty. The only thing to note is that if you can demonstrate that you have complied with your general environmental duty, that will be a defence to this transitional offence. So again, understanding the general environmental duty and getting your ducks in a row to demonstrate that you get it and that you're implementing it will be key to minimising your risks moving forward. So I might now hand over to Sophie to talk about the permissions regime.
Thanks, Jane. So there is a new permissions regime that has been implemented by the new legislation. And I say that because there are 2 new types of approvals that have been introduced, and they are called permits and registrations, and they are seeking to capture the medium to low risk activities that were previously not regulated under the old legislation. So if we're looking at the pyramid on the left of your screen, licenses are still in place. So if you've had a license under the old system, you will have an operating license under the new system. But what is new is that middle and bottom section of the pyramid relating to permits and registrations. So permits are for the medium risk activity, and you effectively have to apply for those, and the EPA will grant you a permit, and it will be subject to certain conditions. The registrations are, once again, you apply for them, but they automatically are granted after 10 days. And there, from a policy perspective, we understand that they're more trying to capture activities that the EPA just wants to be aware that are occurring. They are regulated in the sense that they have some sort of standard conditions that will apply, but they, yeah, as I said, they're automatically granted. So it's a slightly quicker and less arduous process than, say, a permit or a license, which are for your medium to high risk activities. So an example of where you might need a permit is if you are operating an animal, like a farm, and you have greater than 5,000 head of cattle or sheep or goats, and you are discharging or depositing waste solely to land, you might now need a permit to do that activity. In terms of a registration, an example might be that previously if you had waste tyres on your farm and you have less than 5,000 EPUs, and so when I say EPUs, I mean the equivalent passenger unit, and that is effectively where the EPA says that one tyre doesn't necessarily always equal one EPU. So big tractor tyres might equal 20 EPUs. So if you have less than 5,000 EPUs, previously you didn't need to tell the EPA that you were storing those on your farm, but now you need to register that activity with the EPA, and after 10 days you'll get this automatic registration from the EPA. And so the key takeaway clearly is that activities that you previously didn't need to have any form of approval or weren't regulated under the old system now may be regulated. So the key recommendation we're making to all of our clients is that you need to sort of have regard to the new permissions regime, and you need to consider whether any of your activities will fall within the definitions in the regulations, and have a look at those regs. Think about your activities. Are any of my activities now falling within a registration or a permit that I now need to sort of go online to the EPA and sort that out? And I understand that the Victorian Farmers Federation has done a fair bit of work on this aspect. And if you do have any questions or concerns about whether you do now need a permit or a registration, we're certainly here to help, but also, Luke at the Victorian Farmers Federation is also available to help answer any questions you might have. The second key takeaway about the licensing regime is that if you did have a license under the old regime, as I said, that will still apply, but there may be new conditions that are imposed as a result of that license. So the EPA has a period of time in which they can update those general conditions. And so we had a few clients who are operating sort of big facilities that basically as of 1 July were sent their updated license, but that might not be the case for all license holders. The EPA has produced guidance as to what those new general license conditions might look like. So once again, the key takeaway is we're encouraging our clients that do have licenses to go and have a look at that guidance, to be engaging with the EPA about what their license conditions might be in the new regime, or if they're getting updated. So they're the two key takeaways with respect to permissions. I have just seen a question has come through about permissions, talking about disposing of dead animals and whether that requires a permit. Dead animals are considered a waste, and they are, I think they are easily an industrial waste, and I am just thinking about whether they were also, I think they're still industrial wastes under the new system. And so in order to dispose of the waste, there are some obligations with respect to that activity, and there may be permissions dependent. Generally, the permissions would depend on the volume of the waste. So I'll talk about that when I get to the waste section. There's another question about the cost of the license. So once again, the regs will set out whether you have any levies payable with respect to your licenses, and there generally are costs associated both with the application and you may have some ongoing fees, but that's normally set out in the regulations, and it depends on, once again, the type of activity that's being undertaken. Are there any other questions about permissions before I move on to noise?
Sophie, just on the question around the disposal of livestock, perhaps that's something that we can follow up and give a response on.
Yeah, absolutely.
Cool.
Sophie, I've got a question about permissions.
Yep.
How do you, which way do the permissions go? Is it equally back the other way as what we have to, our way? Like we have to, as you've just highlighted, permits, licenses and so forth. If an EPA person wants to,
Into your land.
has reason to think they need to investigate your land, do they need permission or whatever you want to call it to go back the other way?
So no, the EPA has, I mean, if you think about it, it's a bit more like the OH&S regime now. The EPA has broad powers to enter your land, to investigate, to seek information for the purposes of discharging their statutory duties. So they will.
Yeah, sorry. And are they allowed to do that under the pretense of doing it through something else? Such as aerial footage, permits to build sheds.
I think permits to build sheds probably isn't something that the EPA would be concerned about. I think that's more maybe a council issue, like a planning issue. But
No, sorry, I haven't made that clear. So there's been 2 incidences up here where there's been a application to build a shed, and that is done, the footage is done aerial, not on site, due to logistical long ways to go. So now it's done. And whilst that's been investigated as to whether the permit can be granted for the shed building, at the same time, there's been a, well, what most farmers call a Bunnings store next door in their earth tanks. And of course, there's been fines applied to that. So the council have then used their looking at the area to build a shed or give a permit for that, have then noticed something else, and then of course given that to the APA officer, which in turn has then issued fines under that guise. And if they didn't apply for the permit for the shed, well, they would have been none the wiser. I'm not saying that the farmer was wrong or right here. That's not my argument. My argument is the council and the EPA have worked alongside one another then to issue fines against something, which then when we investigated it and we went forward to work with that, we went to the council and said, well, the council did not have the services for that farmer to be able to dispose of his things that he recycles. So that the things that were there that he had purposely put there were for recycling. So it became this, in the end, it just got let go because neither one nor the other could come to an agreement. And I just think it's very sad if we're going to be going down this path of big brother, big stick approach and be using Google Earth and things like that to then enforce fines when all along the farmer was just wanting to build a shed.
Yeah, look, I think the EPA, one of the reasons why this whole act has been overhauled is because the EPA came under a lot of criticism about not being a modern regulator, being too friendly with industry and sort of not being the regulator that it should be in terms of its role is to protect human health and the environment. So I think that you will see a different EPA compared to the EPA of say 5 to 7 years ago, which probably was a bit more sort of helping rather than sort of enforcing the law, I guess. And the other observation I'd make is that a lot of the changes in the Act are designed to ensure that the EPA can work with other regulators, including, WorkSafe, local councils, and really sort of join up forces in terms of enforcement activities. But at the end of the day, the EPA has only got its own statutory powers and functions, and so it needs to operate within the parameters of the powers that are given to it in the law. So they don't have sort of free rein to sort of go off and enforce things that they don't have power to enforce. But how they find out about things is probably using those more modern techniques of aerial surveillance and the like as well. So,
yeah, look, if council enter or aerial survey to look at a shed, I mean, both Jane and I have, definitely experienced where they'll give if they've noticed something, there's this interagency communication protocol. They'll give the EPA a call and say, I've noticed that there's, X, Y, Z happening. You might want to go and check it out.
Yeah. So, well, the next question I have in saying that, so then they have their own powers and jurisdictions to enter on and off your property as they see fit to investigate whatever they do. So then what brings about biosecurity coming onto farm property, and then the next level of a farmer has every right to be dealing with pest animal control. So how do you deal with the situation of someone that you do not know has entered your property because they don't need your permission to enter your property? And in the likelihood that you were dealing with vermin control in that area and that EPA officer was shot. Number two, they have not met regulatory biosecurity means to enter your farm. So there's lots of biosecurity measures, and a lot of farmers do have those measures in place.
Yeah.
So
the EPA
where does that?
Yeah.
Where does that work with that?
If the EPA are entering your land, they still have to comply with any other laws that might be in place, and they should also comply with any reasonable directions that have been given to modify how they enter the land. So I'd be alarmed from a safety and biosecurity perspective if the EPA were entering land and not notifying the owner or occupier of that land. And
I can tell you here, we've had 2 incidences where the EPA officer